You want to let AI practice law? Well, if you're not careful, it may cost you thousands of dollars in fines and get you kicked out of the courtroom. That's exactly what happened in Wyoming this week. Ladies and gentlemen, the verdict is in. The legal equivalent of getting caught using Wikipedia as the only source on your research paper has just played out in a court in Wyoming. The outcome is actually quite severe, but also instructive. Judge Kelly Rankin of the U.S. District Court in Wyoming has sanctioned 3 attorneys for submitting a motion that cited 7 non existent cases that were generated by artificial intelligence. In the court's 17-page opinion, we get a lot of guidance on what the attorney obligations are when using AI in legal practice. The sanctions were distributed based on each attorney's level of involvement. The drafter, he received a $3,000 penalty, the harshest of the penalties, and a revocation of his pro hoc vice admission. Pro hoc vice is Latin for only this time. Let's say your client gets sued in Wyoming, but you only practice law in New York. What do? Well, you go to the judge and you ask for permission to represent your client in this jurisdiction, even though you haven't taken the bar there. This revocation means that he's no longer able to represent his client in that case. The supervising attorney was fined $1,000 despite not drafting the motion. Local counsel also received a fine of $1,000, even though she had no involvement in the drafting of the motion. The court emphasized several very important points that should serve as warnings to all the attorneys out there who are looking at AI. Number 1, everyone's responsible. The court rejected this argument that only the attorneys that drafted it should be sanctioned. Here, the court went after everyone who signed it. It's kind of like co-signing a loan for your unreliable cousin who swears he's good for it. The bank doesn't care who filled out the paperwork when they come to repossess your car, right? So Judge Rankin stated, similarly, one who signs a motion or a filing and fails to reasonably inspect the law cited therein violates Rule 11 by its express terms. The rule that she's talking about is from the Rules of Civil Procedure, which are essentially the manual of procedures and processes that you use when you file cases in federal court. Number 2, sophistication mattered. The court specifically noted that these attorneys worked at big law firms. These are prestigious law firms with deep pockets and a lot of resources. It's kind of like being caught shoplifting when you have a platinum credit card in your wallet. The judge isn't buying this "we had no other choice" kind of defense. Unlike previous AI hallucination cases where attorneys had limited research tools, the court highlighted that in this case, the attorneys belonged to a really big law firm, a prominent law firm with presumably deep resources. Number 3, red flags were ignored. The court pointed out that the hallucinated cases lacked pin sites and proper citation format. It's like buying a Rolex watch from a guy selling them out of a trench coat and being shocked when your wrist turns green. Judge Rankin noted these deficiencies were certainly noticeable on the motion's face, despite having no knowledge of the use of AI. In a court filing, you usually point to other similar cases to back your legal reasoning. These citations need to be in a format so that anyone can find it, so that especially the judge can find what you're trying to cite to. And that's why we need standard citation formats. And pin sites point the reader to specific pages or paragraphs that you're referencing. The fact that these were missing is a huge red flag. Number 4, technology doesn't change professional obligations. The court emphasized that while technology continues to change, This requirement to make reasonable inquiry into existing law remains the same. In other words, just because your Tesla has autopilot doesn't mean that you can take a nap in the back seat and then blame the car when you crash into a cow. Interestingly enough, the court declined to sanction the attorney's law firms, noting that the firm had already implemented appropriate AI policies and additional training after the incident. The court acknowledged that any further sanctions would be greater than necessary. The court's message is clear. Attorneys can't delegate their professional responsibility to verify the legal authority, whether it's to other attorneys or to AI tools. As Judge Rankin concluded, the key takeaway for attorneys is simple. Make a reasonable inquiry into the law before signing or giving another person a permission to sign on your behalf. That's required. That's required by the rules. This ruling serves as a sobering reminder for legal professionals that while AI tools can enhance efficiency, they cannot replace the attorney's fundamental duty to verify the accuracy of their work. It's like spell check. It's fantastic for catching typos, but it won't stop you from writing "I love your mother's lasagna" when you meant to say "I love you more than lasagna." For legal professionals everywhere, the lesson is clear. Check your sources every single time, because the next AI-generated rabbit hole you might fall into might cost you more than your dignity.